Welcome to my channel. Please like, comment, and subscribe. Seamen and offshore workers put themselves at risk every day of suffering a serious injury at work. There are many dangers present while working on offshore vessels, such as fires and explosions, gas leaks, heavy objects falling, and extreme weather conditions. Maritime law serves to protect workers at sea and ensure that in the event of an injury, they are afforded sufficient compensation to cover the cost of maintenance and cure. Understanding maritime law can often be complex, and many workers are unsure under which maritime law act they should file an injury claim. We have seen many workers accept compensation claims from their employers that did not adequately cover their injury cost and which they were not able to change at a later date. As such, it is extremely important that you speak with an experienced offshore accident lawyer as soon as possible if you have been injured offshore. At Abraham Watkins, we have a team of maritime attorneys that can help you at every stage of your case. We know how difficult and stressful it can be to be injured at work and have to worry about paying for all of your costs. Because of this, we want to help you file a claim under maritime law to get compensated for your injuries and ensure that your rights are protected. And then the next is, what is maritime law? Maritime law, sometimes called admiralty law, is a set of laws that applies to maritime workers, employers, and bodies working on the high seas. Generally, the laws govern all maritime accidents and events that occur on the high seas, such as oil platform accidents, dredge accidents, and cargo ships accidents. The high seas refers to water beyond the territorial waters of a country or state. Maritime law also applies to territorial water that is within 12 miles of the shore. Maritime law functions as one of the oldest sets of laws in the country, and as such, it experiences constant change. Traditionally, maritime law only applied to accidents and events that occur on the high seas. However, it now applies to all navigable waters in the United States. Defining navigable waters under the law can sometimes be confusing, and most of the law that we use today is based on previous cases attempting to offer a clearer definition. Currently, navigable waters is defined as a water that can act as a continued highway over which commerce is or may be carried on with other states or foreign countries. So, if a body of water enables to trade or commerce with another state or a foreign country, it is governed by maritime law. Bodies of water that are part of a greater navigable waters will also be governed by a maritime law, even if they do not directly connect to another state or country. As such, a body of water that is closed off by a larger piece of land or landlocked will be governed by state law rather than federal maritime law. And then, where are maritime cases heard? In Houston, Texas. Texas, our state maritime law is based entirely on several laws as provided by Article 3, Section 2 of the United States Constitution. As such, the federal courts have jurisdiction over all cases involving personal injury and damage to property on navigable waters. The only area that state courts may apply their own discretion is in relation to the compensation process of victims. Although federal law governs all maritime injuries, injured workers and seamen are entitled to bring maritime claims in state and federal courts in Houston. Injured maritime workers can bring a personal injury claims under the Jones Act in Texas state courts, and all rig workers can also bring a federal law case to a state court. The crossover between state and federal maritime law can be confusing, and often workers are unsure whether they can bring a claim to a Texas state court. One of the offshore accident lawyers from our law firm can offer you advice on your injury case and help you bring your case to a state or federal courts. Important maritime law acts in Houston, Texas. Maritime injury cases and property damage cases are dealt with using a series of acts and general maritime law principles that have been built up over many years. Legal principles governing the right to compensation and medical expenses for an offshore injury and jurisdiction for claims are set out in this Act. And then Longshore and Harbour Workers' Compensation Act. The Longshore and Harbour Workers' Compensation Act, or LHWCA, serves to compensate many different types of maritime employees and is not limited to just a seaman. Some examples of workers that can claim under this act include harbor construction workers, longshore workers, dock workers, ship repairers, shipbuilders. In order to make a compensation claim under this act for a maritime injury, the worker must demonstrate that their injury occurred on navigable waters or adjacent to such waters, including docks, piers, and etc. And then the next is Outer Continental Shelf Lands Act. The Outer Continental Shelf Lands Act is extension of the LHWCA. Workers who are injured on the Outer Continental Shelf on the United States are entitled to make an injury claim under this act. They must show that their work was in a relation to exploring and producing natural resources. If you work on an Outer Continental Shelf oil rig, you may be entitled to file a maritime injury claim under this act. However, if you are employed by the U.S. government, a foreign government, or a state government, you will be exempt from filing a personal injury claim under the Outer Continental Shelf Lands Act. And then Death on a High Seas Act. All deaths that occur on a high seas outside of states' territorial waters are covered under the Death on a High Seas Act. This act provides that family members of workers and passengers who die due to an accident at shore caused by a wrongful act, neglect, or default occurring on a high seas can bring a lawsuit. Family members can only recover compensation for pecuniary losses like financial support and will be enabled to recover medical expenses and funeral costs. The statute of limitation for bringing claims under this act is 3 years. And then Jones Act. The Jones Act, also known as the Maritime Act, was established in 1920 and covers the right of a seaman to file claims against the employer for an offshore injury. Under the Jones Act, workers have the right to file a compensation claim against the employer if they were wholly or partially responsible for their injuries. As such, the employer only needs to play a part in causing the personal injury you suffered to recover compensation. Some incidents of negligence covered under this act include failure to maintain and prove safe equipment for seamen, having knowledge of extreme weather conditions and not taking steps to avoid them, knowingly giving negligence order and instruction to workers failing to provide medical treatment to injured workers. Injured seamen can make a personal injury claim against the employer for whole or partial negligence in a state or federal courts. Workers also retain the right to jury trial to bring a claim under the Maritime Act. You should speak with an experienced maritime lawyer who can help you with your claims. Claims under this act can often be complex, and a Texas lawyer can help gather evidence on your behalf, build a strong case, and ensure that you receive proper compensation for your injuries. And then the next is Limitation of Liability Act. The Limitation of Liability Act allows vessel owners to limit their liability for claims brought in relation to injuries and damages caused by their vessel. This means that if you are injured on any type of a vessel, such as personal watercraft or a cargo ship, and suffer serious injuries as a result, the owner of the ship may be able to reduce the liability and minimize the amount of compensation you can recover. In order to use this act, vessel owner must demonstrate that they have the previous knowledge of problems or damage relating to the vessel. In cases where the Limitation of Liability Act is raised, a judge must be the sole decider, as it is governed under admiralty law, which is slightly different than maritime law. If a vessel owner decides to try and use the Limitation of Liability Act, the amount of compensation you will be able to recover will be substantially lower. As such, it is recommended that you seek help from experienced maritime attorneys who can demonstrate that the vessel owner did in fact have prior knowledge of the dangers of using the boat and that they should be found responsible for your injuries. I think that's all, guys, the information that I can share to you. Thank you so much, guys, for watching. I hope you like the video that I've shared to you, and I hope you can take advantage from the video that I've shared. Don't forget to give a like, comment, and subscribe to this channel. Bye bye guys, see you in another video.